To start with, let's go to the definition of a performer in section 2QQ of the Act. The definition includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. Now, a performance is defined as any visual or acoustic presentation made live by one or more performers. In 2012, the Copyright Act was amended and the definition of performer was also amended by way of insertion of a proviso. The proviso reads as follows: provided that in a cinematograph film, a person whose performance is casual or incidental in nature and in the normal course of the practice of the industry is not acknowledged anywhere, including in the credits of the film, shall not be treated as a performer except for the purpose of clause B of section 38B. That provision is not of much concern for the moment, as it deals with the moral rights of the performer. The insertion of this proviso has raised some very interesting and important questions relating to the scope of performers' rights, especially from the perspective of who a real performer is. The main controversy is relating to the rights enjoyed by one, film actors, and two, people who sing, the playback singers in movies. Now, one argument is that a performance has to eventually be one that is made live, and that neither film actors nor playback singers are performing in live. But the one judicial opinion that we currently have on this issue, which of course is not directly on the point because this was a case that could be and indeed was ultimately decided on a separate legal argument. This is Neha Bhasin's case. In Neha Bhasin's case, the Delhi High Court has made a few stray observations to the effect that a performance which is made in a studio is also a live performance. Now, if a performance that is made in a studio is a live performance, it has serious implications for the scope of royalty sharing in the entertainment industry. And the reason for this is because the 2012 amendment not only does insert a proviso to the definition of performer, the one that we have seen thus far, but it also expands the scope of the performer's rights. And how does it do so? To do this, let's just go to a brief historical survey of how performers' rights came about in India. Performers' rights were introduced in the Indian legislation in 1996 by way of an amendment. So the 96 edition of performers' rights conceptualized the scope of these rights as being similar to what we saw with the Rome Convention. Therefore, if the performer had consented to his incorporation of the performance as part of a cinematograph film, then the performer lost all subsequent rights in respect of reproduction and communication of that performance to the public. However, the 2012 amendment has changed this position. The 2012 amendment clearly delineates the various rights enjoyed by the performer, and it provides for the payment of royalties in case of making of the performances for commercial use. And this right is, in my opinion, akin to the equitable remuneration right introduced by the WPPT, that is the WIPO Treaty on Protection of Phonograms and Performances. So where does this take us? It takes us to a situation where, if we were to concede that a film actor or a playback singer were performers for the purpose of this enactment, then even if they were to consent to the incorporation of their performances respectively as part of a cinematograph film, they would be entitled to royalties for any use of that cinematograph film other than by way of enjoyment by the producer of the film of the performer's right in the same film. Therefore, for any subsequent use made by the producer of the film of that particular performance, he would still have to share royalties with the performer. And indeed, this has been made a sort of non-waivable right. So the position as it currently stands is such that the performer can make a choice. He can either choose not to incorporate his performance as part of a film or to go ahead and do so. If he does not incorporate the performance, then he continues to enjoy all the rights in respect of that performance, including the right to make a sound or visual recording of the performance and reproductions and broadcasts of the performance. If on the other hand, he were to permit the producer of a cinematograph film to incorporate it, then the producer shall enjoy the rights of the performer in respect of that film. But in any case, the performer shall be entitled for royalties in case of performances being used for commercial use, and more importantly, the performer does not lose his performance right in respect of other films or in respect of broadcast of that performance, or even in a situation where the producer of the earlier film were to modify the performance and use it, or were to modify the film and incorporate the same performance in that modified film. So in all these respects, the performer would continue to exercise his performance rights, and this really goes to further uses of the cinematograph film, such as, for instance, remake of the film, even the translation of that film, or the dubbing as one would popularly know it, of the film in a different language, and so on and so forth. So if the performer's definition extends to studio actors and playback singers, then there is a clear difficulty in delineating and contracting of rights insofar as the actual cinematograph film itself is concerned. Currently, we do not have a conclusive answer from the judiciary because the matter has yet not gone to court for adjudication, and the amendment is a relatively new one. Now, leaving the matter of scope of rights of the performer in strict copyright terms aside, Section 38B, which was also introduced in the 2012 amendment, provides for moral rights akin to what we saw with the WPPT in respect of the performance. So the performer again here has the right to paternity and the right of integrity of performance. So moral rights are provided. Again, the duration of performance rights is being extended by the 2012 amendment from 25 to 50 years. So in fair measure, there has been an expansion of performers' rights in the 2012 amendment. Now, how do these rights come into conflict with, or the interplay between these rights and the copyright in respect of cinematograph, film and sound recordings? This is a matter that we will take up soon, but after discussing broadcasting rights. Broadcasting rights, or broadcast reproduction rights as they are better known in India, were internationally recognized again for the first time in the Rome Convention in 1961. So the whole purpose behind these rights, as initially conceptualized at least, was to grant a limited right to commercial entities engaged in the business of broadcasting in respect of their signals. The idea was in fact to give them an independent right to sue. The reason is evident once we think of the kind of content that broadcasters deal with. It is content for which, in respect of which copyright would be with various different entities. So what happens when a pirate captures the signals of the broadcaster and airs the different programs which are relayed by the broadcaster on its private channel? Is it technically or practically feasible to expect each of these copyright owners of these various different programs relayed on the broadcast station to get together and sue the pirate? Due to the practical difficulty of this, and considering that the broadcast by itself, along with the advertisements and different contributions made by the broadcaster, including the sequencing of the different programs and so on and so forth, had independent value, it was thought fit to recognize rights of reproduction over the broadcast and rebroadcasting of already broadcast programs. So let us quickly see the scope of rights as envisaged by the Rome Convention before we proceed to discuss the law in India on broadcast reproduction. Article 3F of the Rome Convention defined broadcasting as the transmission by wireless means for public reception of sounds or of images and sounds. Rebroadcasting was defined as the simultaneous broadcast by one broadcasting organization of another's broadcast. The minimum rights of broadcasting organizations were the authorizing or prohibition of A. the rebroadcasting of their broadcasts, B. fixation, C. reproduction of such fixations, and D. the communication to public of the broadcast. 20 years was the duration of the broadcast right, and this was computed from the end of the year in which the performance or the broadcast took place. Article 15 of the convention also provided that broadcast reproduction rights could be made inapplicable to instances of private use of excerpts in connection with reporting, ephemeral fixation by broadcasting organizations, that is the temporary fixation for the purpose of its own broadcast, and sole use for purposes of teaching or scientific research. There is no WIPO treaty yet on broadcasting, and therefore the international position has almost come to a standstill with the Rome Convention, though there have been attempts to come out with the WIPO treaty. Nothing on the ground yet.